In the last class, I started with the salient features of the Indian Constitution. And in the salient features of Indian Constitution, I discussed the uniqueness of Indian Constitution. The uniqueness of Indian Constitution is that it is not just a power map, but it is also a social charter. It aims at the transformation of the Indian society. So whenever you study polity, first of all, visualize a probable question that can be asked. So the concept Indian Constitution as a transformative constitution is in news in the recent judgments time and again. So you should be fully prepared that in case a short note is asked in paper 4, 1 or 2, I should be able to write the concept of the transformative constitution. So if in the present time we see Supreme Court has used these terms in different cases, from Navtej Singh Zohar case to Sabrimala case to Delhi LG versus CM case. So how should you present the concept of the transformative constitution? So I told you that India had not gone with the path of violent revolution. Rather, we have chosen the path of silent revolution. Fine. So you will see there are a lot of writers who have written a book with this title, India's Silent Revolution. Means to transform the society, we have chosen the constitutional method, which is also often called as piecemeal social engineering. Social engineering means, like engineering, you create a society. So social engineering, you are doing engineering in the society, you are reforming the society, you are changing the society. So instead of wholesale social engineering like violent and complete change as happened in China, India has went for the gradual process of change, and our constitution is such a visionary document. So today Supreme Court has applied the concept of transformative constitution as a doctrine of the interpretation of the constitution or judicial review. And whenever the situation or whenever the case has arisen, Supreme Court has used this doctrine. Fine. So for example, like what is in short the essence of the discussion yesterday, means you should be prepared to write a short note on transformative constitution. Fine. So first of all, you should write that in recent years there are number of cases in which Supreme Court has mentioned the doctrine of transformative constitutionalism. And what are these cases? Any 2-3 cases will be enough. You can talk about Nalsa judgment, you can talk about Sabrimala judgment, you can talk about Navtej Singh Johar case, you can talk about BK Pavitra case. Fine. And if you have an idea, then just write something about it, and then you can discuss what is the doctrine about. Fine. So the doctrine is applied by Supreme Court whenever, Supreme Court in number of cases whenever it faced issues like social reforms versus traditions. Fine. So, for example, in Sabrimala case, now Sabrimala case is about the temple entry of the woman of a particular age. Fine. Now, those who were demanding that women should be given right to enter, because men also have that right and it goes against the principle of equality, they have held that not allowing women contradicts Article 14, which ensures gender equality also, because equality is a very broad concept. Fine. Whereas those who were adhering or sticking to the traditions, they were giving reference to Article 25 clause 1, which gives freedom to practice any religion. Now, between freedom to practice religion and right to equality, if Supreme Court has to choose between the two, so Supreme Court has to remember the transformative vision of the Constitution, and this will yield to this. So primacy has to be given to the gender equality, because one of the objective of India's constitutional project is to end the patriarchy, to end the caste based hierarchies. Fine. So this is how you should first give a very live example, so that you can communicate to the examiner that you know very practical aspect of it, and then you can enter into the philosophical aspect of it, that India has chosen the path of silent revolution or piecemeal social engineering, and the Constitution becomes the vanguard of the social revolution. Fine. And the entire project or entire scheme of the thing can be explained through Ambedkar's view or Ambedkar's advice that political democracy without social democracy is a contradiction. Fine. Thus, Indian Constitution as a transformative constitution represent one that it aims at bringing the social change, not just eradicating the mistakes of the past, but also to create more egalitarian future in the future, as well as judiciary itself will take Indian Constitution as an organic or the living document. Fine. So after that discussion, you should be in a position that you can write something meaningful on the transformative constitution substantiated with the facts and the concepts in around 150 to 200 words. This practice you have to do. Okay, so now let us understand another concept which is also often referred in the articles, in the Supreme Court judgments, and this important concept is constitutional morality. So what exactly is the constitutional morality? So whenever we study something, our goal has to be very clear. Why are we studying constitutional morality? So the first goal is, I am studying constitutional morality because in case in exam constitutional morality come, I should be able to write clearly and effectively around 150 to 200 words on constitutional morality. For that you have to understand the concept. For that you have to understand the context. You have to understand the contemporary context also, because the meanings of the terms keep on changing and you have to understand its importance, and in case this creates any sort of problem or any negative aspect of it, that also we should understand. Fine. So the concept of constitutional morality. So before constitutional morality, you have to understand the meaning of the concept morality. Morality. Fine. You will study about morality, morals, ethics, reason, etc. in your paper 4. Let us take it in a very simple terms. Morality means morals. Fine. Now moral, what is moral? What is morally correct? Means what is socially correct. Fine. Moral means what values, for example, honesty, being honest and being dishonest. So the wider society consider being honest is right. Honesty, dishonesty, this is what? Value. Fine. One should be honest. Value means something desirable. One should be or one should not be. So which is accepted by the society as right, as desirable, becomes morality. Morality is values, or in simple terms, morality comes from this word moral. Moral means something which is related to morals or values. Values means something valuable, right, or something desirable. Fine. So which conduct, which custom, which practice is moral or immoral? Something is moral or immoral. Something is right and desirable, and something is not right and not desirable. We should have some criteria to determine it. Fine. Morality, desirable or not desirable. So now let us take a practical example. Triple talaq, or let us say talaq e biddat. Fine. Now this conduct, this practice, let us say this practice is moral and so right, and so it should continue. Or this practice is immoral, incorrect, or you not, instead you can say unjust. You can use just, because justice is righteousness, so right and just can be used interchangeably, and so discontinued. Fine. How will I decide it? What is the basis to decide this is moral or this is not? Fine. So I am not an expert of the Muslim personal law or the Quran or Hadith or Shariat. Fine, I am not expert, so I am not entering into that debate, but just let us assume that according to the belief of a big section of the Muslim society, this is a practice in Islam. So I don't want any debate, it is a practice or not. We are just assuming that this is a practice in Islam. Fine. And it is right or it is wrong. It is to be decided on the basis of scriptures. Religious texts, it can be Quran, it can be Shariat or Hadith or whatever. Fine. But if you think that whether this is right and wrong is not to be decided on the basis of any religious scripture, but to be decided on the basis of what Indian Constitution says. And Indian Constitution says, talks about gender equality. So in a court, if you talk about how court will decide, fine. So I am again writing it. To understand constitutional morality, I am giving you this situation. The situation is of triple talaq. And what is a triple talaq? Let us believe that it has been a practice among Muslims. Fine. And judiciary has to decide whether triple talaq is permissible or it is not permissible. So judiciary will have to take a reference. Fine. So there are two references. One reference is the religious scripture, let us say Shariat. Shariat is like Manu Smriti among Hindus, so Shariat is like that, a counterpart among Muslims. Fine. So, triple talaq should be allowed or should not be allowed. There can be a reference that look into the religious scriptures, or you can look into the constitution. Fine. So since it is considered as a practice which has resulted into the oppression of the woman as such, you can say that constitution does not allow any such thing, and constitution stands for gender equality. Now, there is a dilemma for judiciary. So, in a very simple sense of the term, fine, constitution, what is written in the constitution has to be given primacy. Why? Because constitution is the supreme law of the land. Fine. So, what is written in the constitution has to be given supremacy. Fine. But the situation in India is not that easy. Another very simple thing is India is a secular state, and where the religious law cannot dominate over the constitutional law. But the problem is the constitution, the same constitution which gives Article 14. Fine. The problem in India, why this problem comes, or why the problem comes in India, that the same constitution which gives Article 14, that is equality before law. Fine. Article 15, that is state shall not discriminate among the citizens on the ground of religion, race, caste, sex, or place of birth. So, triple talaq is a practice among Muslims. It is not a practice among Hindus. You can argue that Muslim women are being discriminated on the ground of religion. Fine. So this is one constitution, but Indian situation is not that easy. There is nothing black and white in India. Fine. So the constitution which guarantees equality before law, the Constitution which specifies that state shall not discriminate among the citizens on the ground of religion or sex. Same Constitution has Article 25, and Article 25 says people have freedom of conscience, freedom to practice, propagate, profess religion. I will simply say freedom to practice religion. And those who may not consider the argument that it is a violation or it is not permissible, they can say that triple talaq comes under freedom to practice religion. Though in the Constitution itself it is written that Article 25 does not give any absolute rights. Fine. This is subjected to law, public order, morality and other provisions of Part 3. But at least this right is there. Now the second thing is triple talaq comes under the personal law, and Muslim personal law, there is no uniform civil code. Fine. So another problematic thing is that under Article 44 there is a provision for uniform civil code, but it is not a legally binding thing. Article 44 is in directive principles. Article 37 of the Constitution says that they are not legally enforceable. Fine. And then another problem is that there is one judgment of Supreme Court, Narsu Appu Mali case, given by Bombay High Court, which says that personal laws are, or you can say customary laws are beyond the scope of judicial review under Article 13. Now there are many things like Article 13, 25. These things will become more clear when we will discuss fundamental rights. Fine, but I am just giving a little bit reference. So those who don't know 13 and these things, don't worry, I'll come back to you and you will be able to connect the things. Fine. So now the next thing is, what is Article 13? Article 13 says that any law which limits any of the right given under Part 3 can be declared void. Fine. So triple talaq coming under so triple talaq is violating Article 14, but Bombay High Court's judgment says that customary laws will not be subjected to this. So these are the problems. Now in this context, how judiciary has to define, how judiciary has to take the decision. So Article 13 says any law which limits or takes away, abridges any of the fundamental right will be void. So basically it is not very easy for judiciary. Fine. So if I say triple talaq, there are two parties. First, those who are against and those who are for, that state has no right to declare it void. Those who are against, their arms means their grounds will be, they can talk about Article 14, they can talk about Article 13, whereas those who say that no state cannot interfere, for them Article 25 is there, for them Article 44 is there, which says Uniform Civil Code is just a directive and it is not enforceable in any court of law. And then regarding Article 13, there is a judgment of Supreme Court of Bombay High Court, Narsu Appu Mali case, which says that Article 13 does not apply on the customary law. So in this situation, how Supreme Court has to decide? Fine. So Supreme Court, should it favor this or should it favor this? So as you know, Supreme Court has to understand. For example, this is our customary morality. Or this is our social morality. Fine. But this triple talaq, it's a customary morality, it is a social morality, but we have constitutional morality also. Means there is something right and wrong from the perspective of the Constitution. What is constitutional morality? Fine. And the constitutional morality is to, you have to understand the nature of our Constitution. Fine. The nature of our Constitution is transformative. The nature of the Constitution is, it is transformative, means judiciary will have to take the decision which is in favor of social justice, especially in two contexts, with respect to women and with respect to the members of lower caste. So the weight will be tilted in favor of the woman. Fine. So Supreme Court in many of its judgment has pronounced that constitutional morality will prevail over the social morality. I can give other example also. For example, homosexuality. Now, homosexuality was considered as crime under IPC's section 377. Now, IPC's section 377 was based on Victorian morality of the Victorian times. Fine, Queen Victoria's time. Now this Victorian morality later on become in India social morality. Fine, and people in India do not approve homosexuality, the majority. Now, when our constitution grants equality before law, when our constitution regards right to privacy as a fundamental right, when our constitution regard right to life means right to live with dignity. So judiciary, whether judiciary will go for social morality or judiciary will go for constitutional morality. Fine, obviously judiciary will have to go for constitutional morality. Let us say other example. For example, same gotra marriage. Same gotra marriage is considered as taboo, means something not permissible by certain societies in India. For example, in Haryana, the Khap panchayats, they are very much against it and they sanction a sort of a honor killing in case of same gotra marriage or in case of intercaste marriages, also like marriage between upper caste and Dalits. Fine. So these actions, this is social morality. So Supreme Court in one of its judgment over Khap panchayats approach or approving has held that in India the constitutional morality, constitution does not bar an adult person to go for a marriage of its choice. So constitutional morality will prevail over the social morality. Fine. So basically, what is constitutional morality? So if I am understanding constitutional morality from the perspective of GS paper 2, how will I explain constitutional morality? So constitutional morality is also the doctrine of judicial review. So constitutional morality is also the doctrine of the judicial review. Fine. And Supreme Court has used constitutional morality as the doctrine of judicial review while interpreting the constitutionality or legal validity of particular act. Constitutional validity or legal validity of the particular act. For example, honor killings or homosexual marriages or triple talaq. Is it permissible or it is not permissible? So over social morality, what will prevail? The constitutional morality. Fine. So it is a doctrine of judicial review. Now this doctrine of judicial review, constitutional morality is a doctrine of judicial review. Now this doctrine of judicial review is linked to the doctrine of transformative constitutionalism. Fine. So the doctrine of constitutional morality is linked to the doctrine of constitutional or doctrine of transformative constitution. Fine. Means how judiciary will determine what is constitutional morality. So basically, how judiciary will determine what is constitutional morality. Fine. Why this particular question? Is constitutional morality defined in the Constitution? It is not defined in the Constitution. So judges will have to interpret by application of its reason. By application of its reason, by understanding the vision of the Constituent Assembly, the purpose of having the Constitution. Fine. So how judiciary will determine what is constitutional morality? Now the issue is why this is in question, why the question of determination of constitutional morality arises after all. Fine. The reason is it is not written anywhere. So Constitution itself does not tell constitutional morality. It doesn't define constitutional morality. So how Supreme Court will go? How judges will find out? So judges, in order to find out constitutional morality, they have to apply their reason. They have to apply their vivek, reason. Fine. And they have to understand the vision of the Constituent Assembly. They have to understand the entire purpose for which the Constitution exists. Fine. And what is the vision of the Constitution? That the vision here is that Indian Constitution is not just a power map. Fine. So Indian Constitution is not just a power map, it is a social charter. It is a social charter. Fine. So by which you have to take the progressive view. What will be a progressive view? When you move away from patriarchy towards gender equality. What will be a progressive view? When you move away from caste-based hierarchical society to an egalitarian society. Fine. So while interpreting the constitutional morality, Supreme Court takes into account the vision of the transformative constitution. Okay. Now let us understand. I gave you an idea. Let us understand the constitutional morality in a systematic manner. Fine. So suppose I have been asked to write a short note on constitutional morality. If I have been asked to write a short note on constitutional morality, so it is always good in general studies if you write with reference to something happening in the current. Fine. So what we can say that in recent times Supreme Court in various judgments, if you are very clear about the nature of the judgments, so basically various judgments pertaining to the rights of vulnerable sections or weaker sections. Various judgments pertaining to the rights of vulnerable sections. So you know what are vulnerable sections? For example, women. Fine. If I talk about triple talaq. For example, Dalits, if I talk about honor killings, or women and Dalit both, if I talk about honor killings, or if I talk about creamy layer in promotions, etc., or the transgender community, if I talk about Nalsa judgment. Fine. So pertaining to the rights of the vulnerable section have emphasized that constitutional morality, fine, will prevail over social morality or populist morality. Fine. So rather than what the populist morality, fine, the majority doesn't consider homosexuality, or majority may consider transgender is abnormal, but you have to respect the right to live with dignity. You have to respect the right of a woman to make choices, or all these things like right to live with dignity, etc. So you should start your answer with anything, so that you give an impression that you not only know the theory and the basics, but you are aware of the current context. Fine. Now, always try to explore the different dimensions of a particular question. So, giving reference to the current development. After that, try to go for the historical approach, means trace the history of the concept. Fine. And mind that whenever you have to change, you have to write something different, it is essential to change the paragraph. Fine. So in the next paragraph you can say that the constitutional morality term entered into India's public discourse for the first time and when it was the first time, when Ambedkar has made his speech in the Constituent Assembly. So this constitutional morality entered into a public discourse when Dr. Ambedkar has given his speech in the Constituent Assembly, and where he talked about the constitutional morality. Fine. So in the next paragraph you should explain, first of all, give history of it. So it starts in the speech of Ambedkar in the Constituent Assembly. Okay. Then you should also know the context in which Ambedkar was talking about. Fine. So, or what Ambedkar meant. Next thing that you should write is what Ambedkar meant when Ambedkar talks about the constituent or talks about the constitutional morality in the Constituent Assembly. Fine. So Ambedkar has described, he has actually quoted also, Ambedkar has described the concept of constitutional morality by quoting George Grote. So it is fine if you remember or if you are aware of George Grote, or it's also okay because even in your ethics paper you have to study about the prominent thinkers of modern India, and then obviously Ambedkar comes. And there are some very important texts or the speeches of Ambedkar which a student is expected to know in day-to-day newspapers, and all these references come in again. But fine, if you know it, fine. If you don't know, it's okay, fine. So Ambedkar has actually quoted George Grote, but there is no need that you quote it word by word, fine. You just write the essence, fine, by quoting George Grote, by which he defined constitutional morality as supreme, or as a, you can say, as a reverence to the Constitution. So Ambedkar has referred the constitutional morality as a, with reference to how George Grote has explained, and George Grote has explained it as the supreme reverence to the Constitution, fine. Supreme reverence or love for the Constitution. Now in your answers, you should not leave anything unanswered, fine. You should explain this completely. So permanent or supreme reverence to the Constitution, then it is your responsibility while writing answer that you explain it. What does it imply, fine. Paramount reverence is actually the word, paramount reverence, fine. So sometimes you may require to explain the context, fine. What is the context? So Ambedkar was little bit, or Ambedkar was actually not little bit, very skeptical about the future of this country, and the future of India as a nation is tied to its constitution, and that is why our constitution is known as cornerstone of a nation. And if we do not adhere to the constitution, the entire India as a nation, the entire project of India may collapse. So Ambedkar was fearful that in the coming time history should not be repeating itself. Marx, there is one scholar, Marx, who said that history repeats first as a tragedy and second as a farce. So it should not happen that in India history repeats. So what is the history of India? We have been fighting among ourselves and some foreign power taking the advantage. So this time Indians should be determined that history should not repeat. So what they have to do, what political parties in India have to do, what the people holding the high offices in India have to do. So they have to have a paramount reverence, paramount love for the Constitution. So if sometimes I have to sacrifice my religious belief for the sake of Constitution, it is fine. Means all those who are in power, they should have respect for the Constitution, because once the respect for Constitution goes, not only constitutionalism will collapse in India, the entire experiment of India and its emergence as a nation will collapse, fine. So paramount reverence to the Constitution, right, which meant that to secure the future of India all those who are in power should observe the Constitution both in letter and spirit. So there are few words, if you will repeat in your answers: Indian Constitution, the cornerstone of a nation, and all these things. This adds a very substantive value. Fine. So it's about there are certain keywords. You can make a separate diary, start noting down these keywords: key statement, social democracy or political democracy, India Constitution as a foundation stone, social transformation. If you have a good vocabulary and a good control over the language, then only you can manage social science answers. Fine. So this was the context. Fine. So but you can say that, however, in present time the way judiciary has employed the concept goes beyond adhering to the Constitution. In fact, it is not separated, but more than that. Fine. And understanding the transformative vision of the Constitution. And why do you need that transformative vision? At times students say that they are unable to maintain a flow in the answer. So to maintain a flow, you have to start the next line from where you stop. Fine. So transformative vision of the Constitution. But why do you require this? To usher the silent revolution. This is again a very important phrase. If you will use it, silent revolution towards addressing the discrimination or oppressions existing in the Indian society. Fine. So judiciary is not just sticking to adherence to the Constitution, going much deeper. Though when you understand the vision of the Constitution, then also you adhere to the Constitution, but going deeper, it is seeing it as a means by which you can pursue the goal of the social transformation. Thus, defending the progressive vision over what? Over the populist morality. And then you can write with example. For example, in Navtej Singh Johar case, in Nalsa judgment related to transgenders, in Navtej Singh Johar case related to the homosexuality, in Sabrimala case. So this is how you can write about constitutional morality, and in the end you can say that like different doctrines of interpretation, for example, the doctrine of basic structure and the doctrine of due process of law even the doctrine of constitutional morality has been criticized by the experts. Has been criticized. Why it has been criticized? Because of its subjective nature. Because what is constitutional morality, what is not, it will all depend upon judge's reason. Things are very subjective, and some people are fearful even of doctrine of basic structure. They are also fearful that there is a possibility of the misuse, and India has already seen the phases of judicial activism and judicial overreach. Hopefully you are clear with the concept and the contemporary context of the constitutional morality, and now I will show through PPT the key points so that you will be able to do the quick revision. Okay, so we have already done this transformative constitution. Now let us do the concept of constitutional morality. So basically, if you understand the concept, understand the context, you have to just remember few facts to give authenticity to your answer. Fine. So constitutional morality, first you have to understand Ambedkarite perspective. So Ambedkar, the father of the constitution, is perhaps the first person in Indian context who tried to define the intent of the phrase constitutional morality. While addressing the Constituent Assembly in 1948, he invoked George Grote. This is a picture of George Grote to explain the constitutional morality and its significance to the country where democracy is just a topsoil. Means you are introducing democracy, there is a top-down approach, but Indian society is not democratic. Grote described constitutional morality as a paramount reverence for the constitution. Now, important judgments of the Supreme Court. This is another thing. See, concepts you should keep it in mind. Facts should be your notes, and you should be in continuous revision of the facts. So, Supreme Court in Government of NCT versus Union of India held that constitutional morality is not just the forms and procedures of the constitution, you stick to what constitutional procedure says, but provides an enabling framework that allows a society the possibility of self-renewal, means the possibility of social transformation. In Navtej Singh Johar case, constitutional morality cannot be altered at the altar of social morality. This is related to homosexuality. So in society, people may be against that, but if constitution has given right to any person, that has to be respected. When you will do your ethics paper, you will study Rawls' theory of justice. Now Rawls is one of the most or one of the greatest philosophers of the 21st century, and Rawls has given his theory of justice as fairness. And in his theory of justice as fairness, Rawls says that what is the principle of justice? Inviolability of human dignity. Means maybe the majority is saying something, but we have to respect the individual dignity of each and every individual. Fine. So basically judicial interpretations, they themselves are based on philosophy or political philosophy. So what is the basis, like what is a philosophical basis if you justify the argument of judiciary? That maybe the majoritarian morality is against homosexuality, but you have to respect everyone's privacy, you have to respect everyone's dignity. Fine. So I'll come back to this again. And anyway, when you will do your ethics, you will be doing Rawls, and this is a very beautiful statement of Rawls, that justice as fairness demands the inviolability of human dignity. So what is important is that if you read something in ethics, bring here. If you do something here, utilize it. Fine. And when you write in this way, your answer is of a different quality. Fine. You can have a mesmerizing effect in your answers. Okay. So try to do something different. Now Sabrimala judgment, these judgments to substantiate your point of view. The structure of social discrimination must be evaluated through the prism of constitutional morality. Means these are the principles used by judiciary to determine or the legality of any action. Nas Foundation case, constitutional morality as a counterpoise to popular morality. Criticism of the concept. Fine. So some public intellectuals like Manu Singhvi or Attorney General K.K. Venugopal or Solicitor General Tushar Mehta, they have criticized that this is very subjective and it gives lot of powers to the judiciary. For example, Manu Singhvi from the trenches, the doctrine of constitutional morality is dangerous because of its subjectivity. Attorney General of India K.K. Venugopal, he says it is another controversial doctrine like that of basic structure. Solicitor General Tushar Mehta says gives judiciary an opportunity to emerge as a third chamber, means what is permissible or what is not. Thus, constitutional morality provides the basis to transformative constitutionalism, or it is vice versa also. Constitutional morality is important for constitution to be effective and protect Indian democracy from being a tyranny of majority. Fine. So, now I will deal with the other concepts related to the topic. So we have discussed the two important things from this particular topic. One, the transformative constitution, and other, the constitutional morality. And now let us have a quick glance on some other themes of this particular topic. Now from here I have started Indian Constitution, a lawyer's paradise. if you have to answer this particular question, what exactly will you write? That Indian Constitution is known as lawyer's paradise. Why? Why it is known as lawyer's paradise? Because first of all, there are, like, from the very beginning, lawyer's paradise means something which is beneficial for the lawyers. Fine. So if I say, I should be able to explain this, that Indian Constitution as lawyers' paradise, or lawyer's paradise means it is a heaven for the lawyers and it is the hell for common man. Because even if we are UPSC students, it is so difficult to understand the Constitution, but it is heaven for the lawyers. They can take huge pleasure in the Constitution and in terms of their profession also, but it is a lawyer's paradise in the sense that it is criticized that because it is too bulky, there are a lot of provisions and number of times there is a lack of clarity over the meanings of the various terms here. So there is a lack of clarity over the meaning of the various terms used in the Constitution. So what happens because of that? Because of that, it results into numerous legal battles. Which again results into the amendments in the Constitution. So for a common man, it becomes very difficult to understand the constitutional provision. If for any reason it enters into any sort of litigation, then it becomes a paradise for lawyers, because the language of Indian Constitution is not so easy for the common man to understand. Hence it results into lot of legal battles between the individual and the state, as well as the legal battle between the different branches of government. For example, if you can substantiate it, for example, as far as the appointment of judges is concerned, the term consultation, it is not clear whether the term consultation means non-binding or binding. Still you can say the term secularism, it is not clear. So it is a lawyer's paradise. It is difficult for common man to understand. It results into lot of legal battles and ultimately it may contribute to the policy paralysis. This is one of the criticism and one of the reasons why it is a lawyer paradise, because Constituent Assembly was dominated by the lawyers. So if the Constituent Assembly was dominated by the lawyers, obviously this was the natural outcome. So don't waste much time on this, just have a brief idea. So this thing we have already discussed. Indian Constitution as a one more term that you have to understand is that Indian Constitution is a cosmopolitan constitution. So hopefully you have understood what is cosmopolitan. Fine. Some students have asked question, what does it mean? Cosmopolitan constitution means it reflects or it contains many cosmopolitan values. Fine. For example, liberty, equality, fraternity, human dignity. Okay, so it includes lot of values: liberty, equality, fraternity, human dignity, and these are called as cosmopolitan values, means globally accepted. If you see Universal Declaration of Human Rights, you can see these values. So again, not much to discuss. So now let us come quickly to the next section in the first topic. So in first topic, Indian Constitution, we have done the salient feature, and now we will do judicial review, amendment, and the doctrine of basic structure. So the next part of the topic is judicial review, amendment, and the doctrine of basic structure. Now, doctrine of basic structure is mentioned in the syllabus separately, and there is always a question. The frequency of the question, I will say, on the doctrine of basic structure is very high. So we have to understand it quite holistically. So I will discuss the doctrine of basic structure under the framework of the topic judicial review. Okay, and there will be a lot of questions even in prelims from this particular topic. So we will adopt the same format. I will discuss the basic concepts. You can take down the running notes, and in case you have a problem, listen, forget writing, and we will provide you the PPT containing the prominent concerns. Okay. So let us start this topic. Fine. So let us do the doctrine of basic structure, amendment, and the judicial review. So I will recommend, whenever you start any topic, have a look on the previous year question, because previous year question help us in defining the scope of the topic, that these are some vital elements which we should be studying. So I have seen 3 questions since there is a change in the syllabus, and these 3 questions from the topic are: what was held in IR Kohulu case? In this context, can you say that judicial review is of the key importance among the basic features of the Constitution. Parliament's power to amend the Constitution is a limited power and it cannot be enlarged into an absolute power. In the light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending power. So in 2019 the question has come, in 2020 no question has come, so there is a possibility that a question can come in 2021. So starting from inventing the doctrine of basic structure, judicial activism in achieving the ideals of democracy. So analyze the impact of judicial activism. So we will be doing the constitutional amendment, we will be doing the judicial review, the doctrine of the basic structure, and since it is so important and students get a good idea on the doctrine of basic structure, I have also sent you a notes, just a reading material from where very beautifully the entire doctrine of basic structure is discussed. That is from this book, 10 Judgments That Changed India, written by Zia Modi, and this is that article, The Basic Instinct, a landmark in model constitutional jurisprudence, and I recommend you that you read it. You will be getting it in the PDF format, because there are certain topics which you should not just understand literally, try to capture the essence and the soul of this topic. So after this discussion, if you will do this particular topic, our work will be over. Fine. So ultimately now we have to start with this topic, judicial review, basic structure and amendment. And we have to know all these things separately also, as well as we have to know all these things in a integrated sense. Means what is the relation among these three concepts. Fine. So let us start with the basic structure. Fine. So what is the doctrine? If a question is asked, what is the doctrine of basic structure? Now imagine what is going to be the answer of this question. If I ask you what is the doctrine of basic structure, number of times students give very abstract answer, and what I have noticed that they themselves don't know what they are speaking. Fine, they have read something and they start uttering those words literally without knowing those words. So again I am recommending, please change the way you study. Fine. So my first question from this topic is, what is the doctrine of basic structure? Fine. Now the very brief, to the point, and I will say the blunt answer to this particular question is that the doctrine of basic structure. The doctrine of basic structure is a doctrine of judicial review. Fine. So what is the doctrine of basic structure? So basically, the doctrine of basic structure is a doctrine of judicial review. Okay, be very specific in your answers. Invented by the Supreme Court of India. Fine. So the doctrine of basic structure is the doctrine of judicial review invented by the Supreme Court of India. Okay. I am emphasizing on invented by the Supreme Court of India when in Keshwa Nand Bharti versus State of Kerala case 1973. So the doctrine of basic structure is a doctrine of judicial review which was invented by the Supreme Court in Keshwanand Bharti versus State of Kerala case. Fine. So you can say that this is a contribution of Indian Supreme Court towards the constitutional law or jurisprudence. Okay, and you must understand, and it is because of the doctrine of judicial review. It is because of the doctrine of judicial review. Fine. Supreme Court of India becomes the most powerful court in the world. Fine. So briefly speaking, doctrine of basic structure is a doctrine of judicial review. I have told you two extra points, that it is a contribution of Supreme Court to the constitutional law, and it is because of this Supreme Court of India becomes the strongest court in the world. Now you should keep your mind open, thinking why ma'am is saying so, that how come the doctrine of basic structure makes India's Supreme Court the strongest court in the world. Now that thing I will tell later. Fine, let us come back to the very basic thing, that what is, again let us say, what is the doctrine of basic structure. And the answer to this question is that the doctrine of basic structure is a doctrine of judicial review. So you should know what exactly is the judicial review. I gave you the brief idea of judicial review. You should also know that what are the other doctrines of the judicial review and what is so specific about the doctrine of basic structure. Fine. Since the lecture today is focused on the doctrine of basic structure, so I will emphasize more on understanding this particular doctrine, and I will tell you like which questions will be asked in prelims. Fine. But to be very specific, remember it is a doctrine of judicial review. Okay. Now you should know what is the specific purpose. What is the specific purpose of the doctrine of basic structure? What is the specific purpose, or in what context this particular doctrine is used? Okay. So what is the specific purpose? Means in which situation or in which case this doctrine is used. So what is the purpose of this doctrine of basic structure and in which purpose this doctrine is used? Fine. So what is the answer? The answer is the doctrine of basic structure is used when court is examining the constitutional validity. So court is examining the constitutional validity. So when court examines something, that process is known as judicial review. So when you can say court is examining, you can also say then when court is doing the judicial review. So when court is examining, means court is going through the process of judicial review. When court is examining the constitutional validity of amendments. Fine. So the doctrine of basic structure is a doctrine of judicial review invented by the Supreme Court of India to examine the constitutional validity of the amendments. Fine. You have to understand the gravity of this term I am using. The doctrine of basic structure is the doctrine of judicial review applied by the Supreme Court of India to examine the constitutional validity of the amendment. Fine. So please understand the gravity of this particular statement. Okay. So first of all, you have to understand the gravity when I say that the doctrine of basic structure is the doctrine to examine the validity of constitutional amendment. Maybe many of you is still not realizing the gravity of this particular statement. Fine. So you have to understand the gravity, and when I started this particular topic, I told that it is because of the doctrine of basic structure that the Supreme Court of India becomes the most powerful court in the world. Now, what is the link between these two? Fine. So, doctrine of basic structure examines the validity of constitutional amendment, and it is because of this. It is because of this the Supreme Court of India becomes the most powerful court in the world. Now, polity needs lot of application of logic. What is the connection between these two statements? That the doctrine of basic structure makes Indian Supreme Court the strongest court in the world. You have to get the very exact logic. Fine. So the logic is because no other court in the world, no other court in the world, comma, not even the Supreme Court of USA. Fine. Which people normally have this assumption that this is the strongest court in the world. So no other court in the world, not even the Supreme Court of USA, has power to examine or review, the validity of amendment. Fine. So no other court in the world has power to examine the validity of the constitutional amendment. Fine. And on the basis of my teaching experience, I can tell you students don't understand the gravity of this. Fine. So you have to understand that in general, what is the trend? What is the convention? So in general, courts have power of judicial review only on the ordinary law. Fine. So in general, courts have power of judicial review only on ordinary law. Fine. The courts do not have power to review amendment. Fine. So courts do not have power to review amendments. they can only review the ordinary law. Even the Supreme Court of US cannot review the amendments. They can only review the ordinary law. Means you have to understand the difference in amendment and the ordinary law. You have to understand the difference between the amendment and the ordinary law, and you have to understand what is amendment and what exactly is the relationship between amendment and the doctrine of basic structure. Fine. So you have to understand the difference in the amendment and the ordinary law. For example, Citizenship Amendment Act So basically, you should understand the difference in passing constitutional amendment and the ordinary law. So the Citizenship Amendment Act is not a constitutional amendment. It is not a constitutional amendment. Fine. Citizenship Amendment Act is not a constitutional amendment. It is an ordinary law. Fine. Whereas if I talk about 99th Amendment Act, which aimed to establish National Judicial Appointment Commission, that was the constitutional amendment. So Citizenship Amendment Act is amendment in the citizenship law of, let's say, 1955. That is not amendment of the Constitution. So you have to understand the difference in the ordinary law and the amendment. Fine. So point number 1 is ordinary law versus constitutional amendment. Fine. Ordinary law versus constitutional amendments. Point number 1 is ordinary law does not, or ordinary law is not included in the Constitution. For example, Citizenship Amendment Act is an ordinary law. It will not be added in the Constitution. Fine. But NJAC is a constitutional amendment. That is why it was included in the Constitution. So, constitutional amendment is included in the Constitution and it becomes the part of the Constitution. Fine. Some very small, very simple things many students are not clear. Fine. So please make it clear, because if you will not understand the difference between the constitutional amendment and the ordinary law, you will not be able to understand the entire debate of the doctrine of basic structure and why it is so special. Fine. So ordinary law will not be added to the Constitution, but amendment is added to the Constitution. Fine. Let me explain that 25th Amendment Act, or let us say First Amendment Act, it added clause 4 in Article 15. Fine. It becomes the part of the Constitution. Fine. Again, it added Article 31A, it added Article 31B in the Constitution. Okay. Now, another difference between the ordinary law and amendment is that ordinary law is passed by simple majority. And I hope you know simple majority, as in the basic concepts I have already discussed. So ordinary law is passed by simple majority, whereas amendment is passed by a special majority. Fine. Or you can say ordinary law is passed by ordinary procedure, whereas amendment is passed by the special procedure. And this special procedure by which the Constitution will be amended is itself mentioned in the Indian Constitution. So which article? Article 368. It is a different thing that In India, some amendments can be done even by simple majority. For example, the creation of the new state which do not require the procedure mentioned in Article 368, and that is why Dr. Bhim Rao Ambedkar has clarified that though India is a federation, ordinarily federations have the rigid constitution, means it is difficult to amend the constitution, but Indian federation is a combination of the rigidity and flexibility, means some of the provisions of the Indian constitution can be changed even by simple majority. But right now we are talking about those amendments which require a special majority, which require to be passed by the special procedure mentioned under Article 368. Fine. So let us talk about only those amendments that ordinary law is passed by ordinary procedure and ordinary or by simple majority, whereas amendment is passed by a special procedure and the special majority mentioned in Article 368, that is not by less than 2/3 of the members present and voting plus majority of the total strength of the house, and in some cases which have implications for India's federal structure, even the support of not less than half of the state legislatures is needed. Okay, so the only point which I want that at this stage you should understand that ordinary law is different from the constitutional amendment. Fine. Now, in India, Parliament has power to amend the constitution. Fine. Except few provisions which require the ratification by the state legislatures. In India, Parliament initiates most of the amendment. There is no amendment which can be initiated by the state legislatures. So, Parliament has power to amend the constitution. Fine. And Parliament as well as state legislatures have power to make laws. Fine. Now you should be able to make the differentiation between the two types of powers. Fine. So I will say that powers of Parliament. We should be able to make the differentiation between these powers. So you have two kinds of powers. One is called as the legislative power, and the other is called as constituent power. Fine. So when Parliament passes an ordinary law, Parliament is using its legislative power. When Parliament is passing an amendment, Parliament is using the constituent power. Fine. So it is essential that you are able to make the difference between the legislative power and the constituent power. Okay. Now you have to understand that when we have the Constituent Assembly, the Constituent Assembly had two tasks. Fine. The first task was to prepare the Constitution, and the second task was to act as an interim parliament. Fine. Now, after the Constitution came into existence, Constituent Assembly's role was dissolved. But it is said that the Constituent Assembly has not been dissolved, rather it is kept in suspension. Now, if I talk about Indian Parliament, Indian Parliament also has the dual role. Fine. So Indian Parliament acts as Parliament for the entire term, but whenever the occasion arises, Indian Parliament acts as interim Constituent Assembly. So if Constituent Assembly had the dual role, Indian Parliament also has the dual role. So when Parliament acts as the legislative chamber, it passes the ordinary law or money bill also, you can say. Means even money bill is passed by simple majority, but when it acts as a Constituent Assembly, it uses its constituent power. Fine. So when it goes for amendment, it uses its constituent power. Fine. So under the Constitution, Parliament not only acts as union legislature, it also acts acts as the Constituent Assembly, though this is temporary role of the Parliament. Fine. So, Parliament acting as a Constituent Assembly, making an amendment becoming the part of the Constitution. Now understand this technical part, that the doctrine of basic structure is a doctrine of judicial review, and it is used by the court to examine the validity of constitutional amendments. Fine, and let it be very clear that doctrine of basic structure is not needed to examine the validity of ordinary law. Any word that you use, you should be very clear. That is a key for polity paper. So ordinary law passed by simple majority, and amendment is passed by the special procedure given in Article 368 of the Constitution. Fine. So now my question is, why doctrine of basic structure is not used in case of examining the validity of the ordinary law? Why it is used to examine the validity of the constitutional amendments? Fine. So think about the answer of this question, that why the doctrine of basic structure is not used to examine the validity of ordinary law. Fine. So why the doctrine of basic structure is not used to examine the validity of the ordinary law? Okay. What is the answer coming to your mind? The answer that should come to your mind is because to examine the validity of ordinary law, we have the Constitution. Fine. So ordinary law and its validity is examined on the basis of the constitution. Fine. Whether a particular law is in accordance to the constitution. That is the simple meaning of judicial review. Fine. But in case of amendment, the doctrine of basic structure is needed. So, in case of the amendment, the doctrine of basic structure is needed. Fine. So, is basic structure written in the constitution, or whether Constituent Assembly has outlined any features of the constitution as the basic structure? Now we have to ponder on some questions. Whether constitution mentions the basic structure. Fine. Whether constitution give the list of basic structure. Fine. So, do you think that our constitution anywhere mentions what is basic structure? Fine. The answer is no. Whether constitution gives any list of the basic structure, the answer is no. Fine. So, this is an example of extreme judicial creativity. It is an example of extreme judicial creativity. Understand the gravity of this statement. Fine. So, this is an example of extreme judicial creativity. Fine. So, basically, constitution has not mentioned basic structure anywhere. Fine. So, who has invented this? So, actually, judiciary has invented the basic structure. So, it is the judicial innovation. So, here judiciary is telling the basic structure, constitution is not telling the basic structure. Again, judiciary is telling the elements of basic structure from time to time and on case to case basis. It's not that the judiciary had set one day and judiciary has given the list of the basic structure, but from time to time on case to case basis. Fine. So what is the implication of all this thing? So what is the implication when I make these statements? The implication is that judiciary is acting or judiciary is usurping the role of super legislature. So here what is happening is that judiciary is usurping the role of super legislature. Fine. Now what does this term super legislature? Fine. So if parliament is a legislature, then constituent assembly is the super legislature. You have to understand the implication of this term, that judiciary is usurping the role of super legislature or the constituent assembly. Fine. So basically neither parliament nor Supreme Court can usurp the role of constituent assembly. Why? Because constituent assembly is a super legislature. Fine. And parliament as well as judiciary, both are the institutions created by the constituent assembly. Okay. So constituent assembly has created the constitution. Constitution has created parliament and judiciary. Means both parliament and judiciary are under the constitution and they themselves are the child of constituent assembly, and none of these institutions can usurp this particular role. So Supreme Court cannot usurp the role of the constituent assembly. And now if we look in the constitution, constitution is a product of the constituent assembly, and if we look into the constitution, constituent assembly under article 368 has given the role of interim constituent assembly or the power to amend the constitution to the parliament. Fine. So if we read the constitution, Constituent Assembly has given this responsibility to Parliament, and nowhere it mentions that there is any limitation on the amending power of Parliament. Any limitation on the amending power of Parliament. So nowhere Constituent Assembly has placed any limitation on the amending power of Parliament. Constituent Assembly, you have to understand this very specific point, that Constituent Assembly may have put the limitations on Parliament's power with respect to ordinary law, that ordinary law cannot be against the Constitution, but it has not placed any limitation on the constituent power of Parliament. Fine. So, who is putting the limitation? It is judiciary and not the Constituent Assembly, which is putting the limitation on the constituent power of Parliament. So in one way, the doctrine of the basic structure is the attempt, or it is a doctrine which limits the scope of the amending power of Parliament. And Constituent Assembly has not put any limitation. Who has put the limitation? Judiciary. Now, why it is a debatable issue? Because all the three branches are the creation of the same constitution. And how can judiciary usurp the role of the Constituent Assembly? And whether it is desirable that judiciary usurps the role, considering the fact that out of all the three branches of government, judiciary is least representative and least accountable. So we have to understand the constitutional debate on the basic structure. Whenever we talk about the basic structure, the relationship between the Parliament and judiciary comes into picture. the relationship between the fundamental rights and the directive principles come into picture, and the issue of judicial activism comes into picture. So I'll stop the lecture now, and tomorrow we will continue with the fresh mind. In short, let me tell you that from today's lecture you should be able to just understand what is a constituent power, what is a ordinary legislative power, why judiciary is acting like a super legislature. To clear further knots, wait for the next